Hi again, everybody. Welcome back to another episode of Ask the Lawyers. I'm Rob Rosenthal with AskTheLawyers.com. Today we're going to talk about one of those things we hope we never need to use, but when we do, we are certainly glad we have it. And I'm talking about long-term disability insurance. Now, unfortunately, getting what you're entitled to can be a long and sometimes confusing process. And that's where our expert comes in today. He is attorney Mark Whitehead of Mark Whitehead and Associates in Houston, Texas. And Mark specializes in disability benefits, and he's going to walk us through that process. Thank you so much for being here. I appreciate it, Mark. Now, let's start at the basics. What is long-term disability insurance?
Well, long-term disability insurance, or what we refer to as LTD, is basically a private insurance policy, usually through companies such as Unum, Hartford, Aetna, Cigna. Most of the time, it's through an employee benefits package. Sometimes it can be purchased individually, particularly professionals who own their own businesses. But basically what the policy is income replacement in case the insured is unable to work, either through injury or illness, or maybe some combination of the two. And usually it's something that generally will pay a percentage of the person's former base salary.
Now, it occurs to me when you say unable to work, does that vary depending on what the job is, or does it? I mean, let's say I do construction. If I'm not able to do construction, but I can do some other sort of job, does that work, or does I have to be able to do the job that I had the insurance for?
Well, that's a good question. And the way most of the disability policies are structured, for the first 24 months of the policy, the standard of disability is you cannot do your own job. So in your example, if you were a construction worker and were hurt and were unable to go back and do construction, you would meet the standard of disability for the first 24 months of that policy. However, to stay on that policy past 24 months, then the standard usually becomes tougher, and it switches to what we call an any occupation standard. In other words, you cannot do any gainful occupation. Usually there is some salary percentage formula mixed in with that, but sometimes it is a pure any occupation standard. Sometimes it's an any gainful occupation standard. In other words, it has to be an occupation that would at least pay you close to what you were making before. But yeah, it's a very good question. And quite frankly, what we see frequently is that that's exactly what happens, is that people will get granted disability for the first 24 months under the policy. Within 24 months or so into the policy, then people will get cut off when that new tougher standard goes into effect.
We hear about Social Security disability, and then we're talking about long-term disability. How are those different? Do they work together? Explain that to us.
Yes, good question. So these two programs typically go hand in hand. So Social Security disability is a government disability program through the Social Security Administration. So when you pay your Social Security taxes that come out of your paycheck, or even self-employment taxes, or sometimes people refer to them as their FICA taxes, you're paying into two systems. Number one, you're paying into the Social Security retirement system, which is what most of us think Social Security is about. But you're also paying into the Social Security Disability Insurance Program, which is a disability program within the Social Security Administration. And the net effect of the Social Security Disability Insurance Program is that if you are found disabled by the Social Security Administration, your retirement age is accelerated. So, for example, if you're 50 years of age and you are found disabled under the Social Security system, you basically, the net effect is you will get the benefits that you would normally get at your retirement, including your monthly benefit checks. And after a period of time, you would also qualify for Medicare benefits. So that's the government portion of the policy, or of the disability program. The private part, what we were talking about previously, the LTD portion, which is typically something that somebody has through their employer. That is sort of a secondary or supplemental part. And the way that policy is typically structured is it will typically pay you some percentage of your former salary, say maybe 2/3 of your former salary, but then minus what Social Security Disability pays you. So in other words, the insurance company gets the benefit of your Social Security payment. Just to do some quick math, say, for example, your monthly salary was $5,000 a month. Say the insurance policy would pay 60% of that. Well, 60% of that is $3,000. Let's say Social Security comes in and pays you $1,000 a month. Well, the insurance company gets to subtract that, or what we call offset, what they owe you. So instead of owing the base amount of $3,000, they only have to pay you $2,000. In other words, the difference to get you up to that 60% number. So here's how it actually plays out. Most policies require that most private insurance LTD policies or your employer-sponsored policies will require you to file for Social Security disability, usually within 18 months of your first claim for disability, because they want to take advantage of that offset. So they do very much interplay with each other, and practically everybody that has a long-term disability insurance claim also has an associated Social Security disability claim that's going along with it, because the insurance company requires it, because they want to take advantage of that.
I would imagine a lot of people don't realize that they are able to take advantage of that. They probably think, oh, I'm going to be good. I've got this plus this on top of it, where that's not the case.
Yeah. The net effect is that the Social Security offsets the LTD benefit. It doesn't add on top of it. And that is quite shocking to people when they first file for disability benefits.
Well, you mentioned filing for disability. So take us through that process quickly. I know it's not a quick process, but let's say I think I may qualify for a long-term disability. What are my first steps? What is the process?
Well, the process for filing for long-term disability insurance, first off, is to if the insurance policy is through an employee benefits plan, and probably about 95% of the policies out there are through an employee benefits plan, you probably want to contact your HR department and ask them for the procedures for filing through the employee benefit plan. And typically what they will do is they will assign a claim number, they will give you an application, and you will fill out that application and submit it back directly to the insurance company, and that's how the process begins.
Are they often denied originally, or do most of them go through smoothly? Fill us in.
Well, that's somewhat of a hard question. Insurance companies will tell you that they grant most claims. I, on the other hand, as a disability attorney, see all of these denied claims. So these are private statistics. They're not available to the public. So I can only give you my anecdotal observation, but we see people denied all the time for what I would call suspicious reasons. So I would have, my guess is that there are quite a few people who have filed these claims that are initially denied. And then there's certainly a large number of people that were granted an initial 24-month period of own occupation benefits, but then are subsequently kicked off, after that period is expired. The reality is people don't come to me unless they've been denied. So I'm not going to say that they don't grant some claims. I don't see those claims. I see the claims.
What are some of the reasons that they may deny initially?
Well, the most obvious reason is that they will say that you don't meet the standard of disability. In other words, that either your injury or illness doesn't prevent you from working at your own occupation. However, sometimes you dig into it a little bit deeper. Their claims can also be denied because they're deemed to be pre-existing conditions. Unlike health insurance and the Affordable Care Act, which basically is purported at least to eliminate pre-existing conditions in health insurance, pre-existing conditions are still very much alive and well in disability policies. Also, things we can see are how an employee is classified. Their job description can be incorrect. They may be classified as a certain type of employee, but when you actually look at what they actually did, that may not match their job description. And frequently people are denied on that basis. when basically the insurance company doesn't understand the physical or mental requirements of the job, usually because of faulty job descriptions.
And so once there's a denial, there is the opportunity for an appeals process, correct?
Correct. Now, if it's an employee benefits plan, again, which most insurance policies are, they are usually governed under a federal law known as ERISA. ERISA stands for the Employee Retirement Income Securities Act. And ERISA governs all sorts of employee benefits, whether it's 401k, health insurance, life insurance, or in the case we're talking about now, disability insurance. And under ERISA, there is an established procedure set up for the claimant to appeal a denial. And that denial is triggered by a written letter. You have to receive a written letter stating the reasons for your denial, and it has to spell out your rights to appeal. And what that letter will say, usually around the last paragraph or the second to last paragraph, it will spell out that you have 180 days to file an appeal of that claim. What that letter doesn't say is that this appeal is, in effect, the trial of your case. I mean, it certainly doesn't indicate that you probably ought to consult with an experienced ERISA attorney to understand how to perfect that appeal, what type of evidence you need to submit during that appeal, and the other things that you need to know how to do to put your best case forward during that appeal, because that's really the trial of your case.
So if it's denied again, are you done? Is that your last opportunity?
So if it's denied again, what we would call a final denial during the administrative process, you do have a right to seek federal court review before a federal judge. But that case is different than anything you've ever seen on TV. The federal judge only gets to review the evidence that was submitted during the administrative appeal. There's no new evidence that can be submitted. You don't get to get on a witness stand and testify. There's no true trial of your case before the federal judge. The federal judge is just reviewing the evidence that was submitted during the administrative appeal and reviewing the process. Quite frankly, it's very boring. You would never see this on an issue or an episode of Law and Order. It would really bore everybody to death. But that's why the administrative appeal is so important, because that's your one shot of getting your best evidence in the file. Not only because you want the insurance company to change their mind and do the right thing, but you also want to be able to present that evidence before the federal judge who is going to review what the insurance company did.
So it's obvious.
So the administrative appeal is really your one bite at the apple in terms of submitting your best evidence.
Right. And so it's obvious you want to have an experienced attorney, an expert in the field to help you. At what point do I get someone like yourself involved, Mark? Is it with the initial application, or is that not necessary? Is it only if there's a denial and appeal? Where should I get you involved in the process?
Right. So, I mean, you can get an attorney involved early on in the process if you choose to. Some people choose to just come and consult with us to look over the application. Some clients wish to hire us to file the application for them. I would say that this is not absolutely necessary, but some people feel it's worth the cost and effort to do so. But certainly a client could, or a claimant actually could do this on their own. It's not really a legal task so much as it is just a good factual basis, a factual task. However, if they are denied and they receive that denial letter, which spells out their 180 days to appeal, it is an absolute trap that the insurance company is more than happy to let you fall into to represent yourself, to do your own administrative appeal. Because there are really some tricks to doing it right, and there's really some traps if you don't do it right that can be fatal to your case. Because ultimately, remember, the way you have to look at it is your ultimate audience is not the insurance company. Your ultimate audience is going to be that federal judge that's going to be looking over the insurance company's shoulder.
I think I know what your answer to this is going to be, but I've got 180 days, so I can come see you 150 days in and still have plenty of time, right?
You can, but I wouldn't advise it. So it generally takes us to put together a proper appeal. It generally takes us about 90 days at a minimum. We prefer 120 days if we can. And the reason being is we really have to develop all of your medical records. We have to get rebuttal evidence frequently from your own doctors. We have to get all your medical records, sometimes certified, which takes time. We generally want to involve a vocational expert to come in and review the case and render their own report. Generally, they're going to want at least 30 days to do that because they're busy people as well. And we generally like to submit it at least 30 days in advance because it gives us time to supplement the record and sometimes find additional rebuttal evidence that may not be obvious when the appeal is first submitted. So we want a little buffer time. So that's generally what we are looking for because it is an effort. So 3 to 4 months is usually what we're looking for in lead time. I will say that I've had somebody walk in on the 179th day, and we filed their appeal. We filed a one-page appeal because that's all we had. And obviously that appeal was not successful. And we did file that lawsuit, and we did have a federal court review it. And ultimately the case was resolved in a confidential manner, but it could have been resolved in a much more favorable manner had he come to us more than 1 day in advance. So wouldn't advise it, but sometimes miracles happen.
I would imagine the whole process can be very frustrating for people, especially because you're assuming they're going through something difficult in their life at that time anyway, or they wouldn't need LTD.
Correct. I mean, this is usually probably the most devastating time of an individual's life. I mean, all of a sudden they've worked their whole life. Most people assume that, they're going to retire 65, 70, and all of a sudden, in their mid 40s or maybe early 50s or wherever they may happen to be in life. And all of a sudden, everything they worked for is now gone and they can no longer work. Sometimes it's a physical problem. Sometimes it's an illness. Sometimes it's a mental or emotional problem that's causing the disability. But it is probably one of the most stressful times in this individual's life. Frequently, people come to us with their family members, and we really encourage people to get their family involved. Sometimes people are not the best historian about their own medical conditions, and especially men. But we always want the wives to come in and tell us what's really going on. Sometimes it's their children, sometimes it's their clergy. But yes, it can be a difficult time. And it's kind of when, you all hands on deck. You need your family, you need your lawyer, you need your social support system to get you through this tough time.
Is there anything else you'd want people to know about if they're facing long-term disability and making a claim? Anything else you'd want them to know about the process?
So here is one thing that really bugs me. I mentioned earlier that the insurance company will require you to file for Social Security disability. And I agree with that. It's a good idea. You should do it as quickly as possible. It basically gives you 2 bites at the apple of getting a disability finding. But what the insurance company will frequently do is they'll recommend one of their preferred vendors to represent you on the Social Security disability claim. And ultimately what ends up happening is you have to sign a waiver of a conflict of interest, and that representative, everything that they're going to learn about your case in representing you in the Social Security matter, they're going to turn over to the insurance company for the insurance company's benefit. And these people are not lawyers. If that was a lawyer, they would be subject to conflict of interest rules, to the ethical requiremthat's that your loyalty has to lie with your client, not with the insurance company. So this is a sneaky little trap that's in the industry, and it really bugs me. They claim that the insurance company will pay for this person's services. The reality is the client pays for it. They just pay for it on the back end, not on the front end, and they don't even realize it. But we see this as a rampant problem within the industry. As an attorney, my loyalty is always to my client. It's never to anyone else, and I'm held to that ethical responsibility by the bar. And this whole encroachment of non-lawyers into a legal problem, I think is a rampant problem within the industry. And so something that people really need to be aware of.
And so the way to avoid that trap is to contact an attorney?
Contact and hire your own attorney. Attorneys work on these cases generally, especially the Social Security claim, on a contingency fee basis. Doesn't cost a client any money out of their pocket to hire a Social Security disability attorney. You want people that are working for your best interest and not for the insurance company's best interest. So that would be my advice.
And you represent people all over the country, correct?
Yes, we represent people all over the country on disability insurance claims. Since they're federal and ERISA-based, we're allowed to practice in any federal court in the country. We generally do bring in local counsel to help us in certain jurisdictions, but anytime it's a federal case, we can handle it in any jurisdiction in the country.
Great. I think you've probably helped a lot of people today, Mark. Thank you so much for your time. I appreciate it.
Thank you. Thank you very much.
My guest has been Mark Whitehead of Mark Whitehead and Associates in Houston. And if you have questions, you want to get in touch with Mark, you can start at askthelawyer.com. You can call the phone number that's on the screen, and also take a second to subscribe to our YouTube channel if you can, so you can catch future episodes of Ask the Lawyers. And that does it for this episode. I'm Rob Rosenthal with askthelawyer.com.